A builder in ancient Babylon finishes a house. The work looks solid. Months later, the roof collapses and kills the homeowner's son. The builder walks free. No execution, no prison. Instead, the court orders something almost impossible to comprehend. Nearly 4,000 years later, they take the builder's own son and put him to death in the victim's place. This wasn't random cruelty. It was written into 282 carefully numbered laws, carved into a stone monument nearly 8 feet tall, designed by a king who believed he had one shot at holding an empire together. What he built instead became the blueprint every legal system on Earth still quietly runs on today. Around 1792 BC, a young man ascended to the throne of Babylon. At that point, a relatively modest city-state among many competing powers, scattered across the fertile river plains of Mesopotamia, in territory that today makes up much of modern Iraq. His name was Hammurabi, and the ambition he brought to his new position would, across the following decades, transform his small kingdom into one of the ancient Near East's most formidable empires. Hammurabi's rise to regional dominance proceeded through a calculated combination of military conquest and shrewd diplomatic maneuvering. He formed alliances with neighboring city-states when doing so served his immediate strategic interests, then turned against those same allies once they had outlived their usefulness, or once circumstances made outright conquest more advantageous than continued cooperation. Over roughly 3 decades of sustained campaigning and political calculation, he systematically absorbed rival Mesopotamian powers, Larsa, Mari, Eshnunna, and numerous smaller city-states, into an expanding Babylonian empire that eventually controlled most of Mesopotamia, from the Persian Gulf in the south to the upper reaches of the Tigris and Euphrates river system in the north. Conquest, however, presented Hammurabi with a challenge that pure military force could never fully resolve. The empire he had assembled contained populations with different local customs, different regional legal traditions, different languages and dialects, and centuries of accumulated local practice governing everything from property disputes to marriage contracts to criminal punishment. Administering this patchwork of distinct communities through military occupation alone, relying on the constant threat of force to maintain order, represented exactly the kind of unstable, resource-intensive governance model that had doomed numerous earlier Mesopotamian empires to rapid collapse once their founding conquerors died or their military attention turned elsewhere. Hammurabi understood, with a clarity that distinguished him from many of his contemporaries and predecessors, that lasting imperial stability required something considerably more durable than military garrisons and the personal authority of a single conquering king. He needed a unified legal framework, a single body of law that could apply consistently across every province and city under his control, regardless of local custom or regional tradition, giving his diverse subject populations a shared, predictable standard of justice that did not depend on the whims of whichever local governor or military commander happened to be enforcing order in any particular district at any particular moment. This ambition reflected a genuinely sophisticated understanding of political power that extended well beyond simple military domination. Hammurabi did not merely present himself to his subjects as a conqueror who had defeated their previous rulers through superior force. He deliberately cultivated an image of himself as something closer to a divinely appointed shepherd of justice, a ruler whose authority derived not simply from military victory, but from a sacred responsibility to establish and maintain righteous order among his people, a role that the following episode will show him reinforcing through one of the most visually and symbolically powerful pieces of political propaganda to survive from the entire ancient world. Hammurabi's own surviving royal inscriptions and correspondence, preserved on clay tablets recovered from various archaeological sites across the former Babylonian Empire, reveal a ruler who took an unusually direct, hands-on interest in the day-to-day administration of justice throughout his territories, rather than delegating this responsibility entirely to subordinate officials and considering his own royal duty fulfilled once the broader legal framework had been established. Surviving letters attributed to Hammurabi include direct royal responses to specific legal disputes and petitions submitted by ordinary subjects, suggesting a ruler who understood his personal, active involvement in the administration of justice as a genuine and ongoing component of his royal responsibilities, rather than a one-time legislative act to be completed and then set aside. This pattern of personal engagement lends additional historical credibility to the image the Great Stele itself projects, of a king whose authority rested substantially on his claimed role as the active, ongoing guarantor of justice throughout his realm, a role that required continuous royal attention rather than a single monumental act of legal codification followed by royal indifference to how that code was actually applied in the countless individual disputes that would inevitably arise across an empire of well over 1 million subjects. The resulting legal code, which modern historians and archaeologists know as the Code of Hammurabi, represents one of the oldest, most extensively preserved, and most historically significant written legal documents anywhere in the ancient world. It was not the very first attempt at codified law in Mesopotamian history. Earlier, more fragmentary legal codes from Sumerian rulers predate it by centuries, and this series' final episode will return to this point in more detail. What made Hammurabi's code historically distinctive was not its originality as a concept, but the sheer comprehensiveness, systematic organization, and public visibility with which he assembled, inscribed, and displayed it, turning what earlier rulers had treated as a relatively narrow administrative exercise into a sweeping public statement about the nature of justice itself, one detailed and complete enough to address subjects ranging from violent crime and medical malpractice to minimum wages, commercial fraud, marriage law, and inheritance disputes, all organized within a single, internally coherent legal framework that any literate subject anywhere in his empire could theoretically consult and understand. It is worth pausing to appreciate the sheer administrative scale of what Hammurabi was attempting to accomplish. His empire, at its height, encompassed a population numbering, by most historical estimates, well over 1 million people, spread across dozens of cities and countless smaller agricultural settlements along the Tigris and Euphrates river valleys. Each of these communities had, prior to Hammurabi's conquest, operated under its own accumulated body of local custom, often administered by local temple authorities or hereditary city elders whose judgments carried the weight of generations of unwritten tradition rather than any centrally sanctioned written standard. Attempting to replace this patchwork of local practice with a single, unified legal framework applicable across the entire empire was not merely an administrative convenience for Hammurabi. It was a genuinely radical assertion of centralized royal authority over domains, family law, property rights, criminal punishment, that had previously belonged almost entirely to local and religious institutions rather than to any distant king, however militarily dominant that king's armies had proven themselves to be on the battlefield. The code, in this sense, represented not simply a legal document, but a direct extension of Hammurabi's political project of empire building, using written law as a tool of centralization every bit as deliberate and consequential as his military campaigns had been. Hammurabi's legal code was not recorded on the perishable clay tablets or papyrus-like reed materials that Mesopotamian scribes commonly used for everyday administrative records, correspondence, and commercial transactions. Materials that, however useful for ordinary bureaucratic purposes, could be damaged, destroyed, or simply lost with relative ease. Instead, the definitive version of Hammurabi's code was carved directly into a massive stone monument, known to modern scholars as a stele, carved from polished black diorite, an extremely hard and durable stone specifically chosen for its capacity to preserve an inscription essentially indefinitely. The stele itself stood as a genuinely imposing physical object, rising to a height of approximately 7.5 feet and weighing several tons, a scale of construction that immediately communicated to anyone encountering it that this was no ordinary administrative document, but a monument of deliberate, calculated permanence and significance. At the top of the stele, above the dense columns of cuneiform text recording the actual legal code, ancient sculptors carved a detailed relief image depicting Hammurabi himself standing before Shamash, the Mesopotamian sun god, who was also understood, within Mesopotamian religious tradition, to be the divine patron of justice and righteous judgment. This visual composition served a calculated and genuinely sophisticated political purpose that deserves careful appreciation. The image did not depict Hammurabi issuing decrees on his own personal authority as a mortal ruler. It depicted him receiving the very symbols of justice and legal authority directly from the god Shamash himself, a visual claim that the laws that followed did not originate merely from royal whim or political calculation, but had been sanctioned by divine authority itself. This was propaganda of a genuinely effective kind for its historical context. A population that might have been inclined to question or resist laws issued purely on the authority of a foreign conqueror could be persuaded, through this carefully constructed religious framing, that resistance to the code meant resistance to divine will itself. The legal text that followed this image comprised 282 individual laws, inscribed in the Akkadian language using cuneiform script, the wedge-shaped writing system, pressed into clay, or, in this monumental case, carved into stone, that dominated written communication across ancient Mesopotamia for thousands of years. The inscription filled 44 columns of densely packed text covering the stele's surface, representing a genuinely massive undertaking of skilled scribal and stone-cutting labor. Once completed, the stele was erected in a prominent, publicly accessible location, generally believed by historians to have originally stood in the great temple complex of Marduk in Babylon itself, positioned specifically where the widest possible cross-section of the city's population, merchants, officials, priests, ordinary laborers, and visitors from throughout the empire conducting business in the capital, would encounter it in the ordinary course of their daily movement through the city's central public spaces. The genuinely striking historical detail worth emphasizing here is that the overwhelming majority of ancient Babylonian society could not read. Literacy in cuneiform script required years of specialized scribal education that only a small fraction of the population, generally those training for careers as professional scribes, priests, or high-ranking administrators, ever received. This raises an obvious and historically significant question. What practical purpose did a towering stone monument covered in dense legal text actually serve for a population that could not, in the overwhelming majority of individual cases, personally read a single word of it? The answer historians have generally settled upon illuminates something genuinely important about how pre-modern legal and political authority operated. The stele's power did not depend primarily on its function as a practical reference document that ordinary citizens would consult directly to resolve individual legal questions, in the way a modern citizen might look up a specific statute. Its power lay instead in its sheer physical presence and symbolic weight, an unmistakable, permanent, monumental statement that law now existed in fixed, unchangeable written form, available for consultation by literate scribes and officials on behalf of any citizen who needed it, and no longer subject to the arbitrary, unrecorded whims of whichever local judge or official happened to be adjudicating a particular dispute on any given day. Even for the illiterate majority, The steel's existence functioned as a powerful psychological and political assurance that a knowable, stable, and theoretically consistent standard of justice now existed, inscribed permanently in stone, rather than residing only in the changeable memory or personal judgment of individual officials who might be bribed, biased, or simply inconsistent from one case to the next. Modern historians studying the code have additionally noted that the original stele was almost certainly not the only physical copy that existed during Hammurabi's reign. Archaeological excavations at various sites across ancient Mesopotamia have recovered fragments of clay tablets containing portions of the same legal text, suggesting that copies of the code, or at least substantial excerpts from it, were distributed to regional administrative centers throughout the empire, allowing local officials and scribes in cities considerably distant from Babylon itself to consult the same legal standard that the great stone stele proclaimed in the capital. This practice of distributing written copies to regional administrative centers reflects a further layer of genuine administrative sophistication on Hammurabi's part, ensuring that his unified legal vision extended in practical, functional terms throughout the empire's full territorial reach, rather than remaining merely a symbolic monument confined to the capital city, while more distant provinces continued operating under whatever local custom had previously governed them. At the theoretical and philosophical core of Hammurabi's legal code lies a principle that modern legal scholars and historians commonly refer to by its Latin name, lex talionis, or the law of retaliation, a principle that survives in popular modern memory primarily through its most famous and frequently quoted formulation, an eye for an eye, a tooth for a tooth. This principle appears in explicit, unambiguous form at multiple points throughout the code's 282 laws. Law 196 states directly that if a man destroys the eye of another man of equal social standing, his own eye shall be destroyed in return. Law 200 states, with the same direct symmetrical logic, that if a man knocks out the tooth of another man of equal social standing, his own tooth shall be knocked out in return. To modern sensibilities encountering these specific provisions for the first time, the underlying logic can appear shockingly primitive, a legal system seemingly built around literal, physical mutilation as its primary response to violent injury, rather than the more familiar modern apparatus of imprisonment, fines, or rehabilitative sentencing that contemporary legal systems generally favor. Understanding why this specific approach represented, within its own historical context, a genuinely significant advance in the development of organized justice requires understanding what came before it, and what alternative mechanism of dispute resolution the lex talionis principle was specifically designed to replace. Prior to the emergence of codified legal systems like Hammurabi's, disputes and violent injuries throughout much of the ancient Near East were commonly resolved through informal mechanisms of private retaliation and blood feud. If one man injured or killed a member of another family, the injured family's response was not constrained by any formal, proportionate standard. Retaliation could, and frequently did, escalate well beyond the scale of the original offense, with an insulted or injured family sometimes responding to a single injury or death by killing multiple members of the offending family, triggering escalating cycles of retaliatory violence that could persist across generations and destabilize entire communities. Hammurabi's lex talionis principle addressed this destructive pattern by establishing a firm, legally enforced ceiling on the scale of permissible retaliation. If a man destroyed another man's eye, the injured party or the state acting on his behalf could demand the offender's eye in return, but critically, no more than that. The response had to be proportionate, calibrated precisely to match the scale of the original injury, rather than left open to the kind of unlimited escalation that informal blood feud traditionally permitted. In this specific historical sense, the principle that strikes modern audiences as savage and primitive actually represented, for its own time and place, a genuinely significant civilizing innovation, a deliberate, state-imposed limitation on the scale of permissible violence, replacing potentially unlimited private vengeance with a formal, predictable, and importantly finite standard of retribution. Equally significant, and often overlooked in popular discussions of eye for an eye justice, was the code's broader effect of transferring the authority to administer punishment away from private individuals and families, and placing it firmly in the hands of the state and its formal judicial apparatus. Under Hammurabi's system, an injured party could not simply take matters into his own hands and personally inflict whatever retaliation he judged appropriate. He was required to bring his case before a formal court, present evidence, and have the court determine whether the lex talionis principle applied, and, if so, formally administer the corresponding punishment through state authority rather than private action. This shift, from private vengeance to state-administered, legally regulated punishment, represents one of the foundational conceptual building blocks of virtually every subsequent legal system in recorded human history, including the modern legal systems that today's audiences in Europe, North America, and around the world continue to live under. However dramatically the specific punishments involved have since evolved away from literal physical mutilation toward the fines, imprisonment, and other sentencing mechanisms modern societies generally favor instead. The practical operation of Babylonian courts responsible for applying these principles also deserves some attention, since the code did not exist in a legal vacuum, but functioned alongside an actual institutional apparatus of judges, witnesses, and formal evidentiary procedure. Babylonian judicial proceedings generally took place before a panel of judges rather than a single presiding official, drawing on local notables, temple officials, and sometimes royal appointees who heard testimony from witnesses and reviewed whatever physical or documentary evidence the parties could produce. Written contracts, a genuinely widespread feature of Babylonian commercial and family life, given the broader Mesopotamian scribal tradition's emphasis on documenting transactions, marriages, and property arrangements on clay tablets, frequently played a decisive role in resolving disputes, since a party who could produce a properly witnessed written record of an agreement held a significant evidentiary advantage over a party relying purely on verbal testimony or general reputation. This reliance on documented evidence, imperfect and unevenly available as it certainly was across different social classes and types of dispute, represents a further, genuinely significant contribution to the broader historical development of evidence-based judicial procedure, distinguishing Babylonian legal practice from systems that relied more heavily on unverifiable personal testimony, oath-taking, or the kind of trial by ordeal this series will examine in more detail in a later episode covering the code's treatment of marital disputes. Judges who rendered incorrect verdicts, once discovered, faced their own significant accountability under the code. A judge found to have issued a judgment that was later overturned on appeal faced a substantial fine and permanent removal from judicial office, forbidden from ever again sitting in judgment over any future case for the remainder of his life. This provision reveals a further dimension of the code's broader concern with the integrity of the judicial process itself, extending accountability not merely to litigants, witnesses, and the parties directly involved in any given dispute, but to the judges themselves, who bore direct personal and professional consequences for demonstrably erroneous judgments, rather than enjoying any presumed immunity from review or correction simply by virtue of their official position. Among the most historically striking and, to modern sensibilities, genuinely disturbing applications of Hammurabi's proportional justice principle involved the construction industry, a sector of the ancient Babylonian economy where professional negligence carried consequences of an intensity that few modern building codes, however strict their safety regulations, would ever contemplate replicating. Law 229 of the Code addresses the most straightforward version of builder liability directly. If a builder constructs a house for a client, and that house is not built with sufficient structural integrity, and the house subsequently collapses and kills the homeowner, the builder responsible for the construction shall be put to death. This provision alone represents an extraordinarily severe standard of professional liability by any historical comparison, holding construction workers personally, capitally responsible for the structural safety of their work in a manner that placed the builder's own life directly at stake with every project he undertook. What makes the Code's approach to construction liability particularly striking from a modern ethical perspective, however, is Law 230, which addresses a specific and genuinely disturbing variation on this same underlying scenario. If a house collapses and kills not the homeowner directly, but the homeowner's son, the punishment prescribed by the Code is not the death of the builder responsible for the faulty construction. Instead, the Code specifies that the builder's own son shall be put to death in the homeowner's son's place. This particular provision illustrates, with unusual clarity, both the genuine logical consistency and the profound ethical limitations of applying the lex talionis principle with mechanical, literal precision. Within the Code's internal logic, the underlying reasoning appears to have been genuinely symmetrical. A son's death demanded a son's death in return, following the same proportional retaliation logic that governed the eye for an eye principle examined in the previous episode. But applying this logic to the specific case of construction liability produced an outcome that strikes virtually every modern observer as a profound miscarriage of justice by any reasonable ethical standard. Punishing an entirely innocent child for a professional failure that the child himself had no possible connection to or responsibility for, while allowing the actually negligent builder himself to continue living. Law 231 addresses a related but distinct scenario, specifying that if a collapsing house kills a slave belonging to the homeowner rather than a free family member, the builder's punishment shifts from any form of capital retribution to a straightforward financial obligation. The builder must simply provide a replacement slave of equivalent value to the homeowner. This distinction, examined more fully in a later episode's broader discussion of the Code's treatment of social class, reveals with stark clarity how thoroughly Babylonian law calibrated the severity of punishment according to the social status of the victim, treating an enslaved person's death as a matter of property replacement rather than capital justice. In sharp contrast to the extraordinarily severe consequences the Code applied when a construction failure claimed the life of a free person or, more disturbingly still, a free person's child. The broader practical effect of these provisions on the actual conduct of the Babylonian construction industry deserves consideration as well. Facing the genuine prospect of capital punishment, whether applied to himself or, in the case of a client's son's death, to his own child, a Babylonian builder had every possible incentive to exercise extraordinary care and precision in his construction work, testing materials thoroughly, avoiding shortcuts, and generally treating structural safety with a level of seriousness that few subsequent historical building trades, prior to the emergence of modern engineering standards and building codes, would match. In this specific sense, historians studying ancient Mesopotamian economic and legal history have sometimes characterized Hammurabi's construction liability provisions as representing one of the earliest documented systems of quality control regulation in human history, a genuinely effective, if ethically troubling by modern standards, mechanism for ensuring that professional builders took the structural safety of their work with the utmost seriousness, precisely because the personal cost of failure, for themselves or their own families, was set at the highest possible stake available to any legal system, human life itself. The Code extended this same logic of substitutionary liability, in which a family member, rather than the actual offender, bore the ultimate consequence of a serious offense, to several other categories of professional and commercial negligence beyond construction alone, revealing that the principle at work in Law 230 was not an isolated anomaly, but part of a broader, consistently applied legal philosophy running throughout the code. This philosophy held that certain categories of harm, particularly those involving the death of an innocent family member through someone else's professional negligence, demanded a response calibrated not merely to punish the specific individual responsible, but to restore a kind of cosmic or social balance between the two families involved. The wronged family's loss of a child answered, in the code's stark moral arithmetic, only by an equivalent loss suffered by the family of the person responsible. Modern legal philosophers and historians examining this principle have noted that, while it strikes contemporary sensibilities as a profound violation of the basic principle that criminal liability should attach only to the actual wrongdoer, the underlying impulse toward proportional, symmetrical restoration of balance between wronged parties reflects a recognizable, if ethically primitive, ancestor of the broader concept of restorative justice that continues to inform certain strands of modern legal and restorative justice theory. However dramatically the specific mechanisms involved have since evolved away from anything resembling the literal, familial substitution that Hammurabi's code so starkly prescribed. The practice of surgical medicine in ancient Babylon represented one of the most lucrative professional occupations available within the broader ancient Mesopotamian economy, commanding substantial fees for successful treatment of serious injuries and illnesses. It also represented, under the specific terms Hammurabi's code established, one of the most genuinely dangerous professions any individual could choose to pursue, given the severe personal consequences the law attached to surgical failure. Law 218 of the Code addresses what modern legal terminology would classify as medical malpractice, establishing liability standards calibrated with the same characteristic severity that governed the construction liability provisions examined in the previous episode. If a surgeon performed a major operation on a patient using a bronze lancet, the standard surgical instrument of the period, and the patient subsequently died as a direct result of the procedure, or if a surgeon operated on a tumor near a patient's eye and the procedure resulted in the destruction of that eye, the code prescribed a severe and immediately enforced punishment, the amputation of both of the surgeon's hands. This particular punishment deserves careful consideration for its evident underlying logic, which extends beyond simple retributive punishment into something closer to what modern regulatory theory would recognize as a preventive public safety measure. By physically removing a surgeon's hands following a serious surgical failure, Babylonian law did not merely punish the individual practitioner for his specific documented failure. It permanently and irreversibly prevented that same surgeon from ever practicing surgery again on any future patient, eliminating any possibility that a demonstrably dangerous or incompetent practitioner might continue endangering additional patients through repeated surgical failures. In this specific sense, the punishment functioned less like a simple penalty and more like what a modern regulatory body would recognize as the permanent revocation of a professional license, enforced through irreversible physical means rather than administrative paperwork. The code's treatment of surgical liability, much like its treatment of construction liability, also revealed the same underlying class-based calibration of punishment severity that ran throughout the broader legal system. Law 219 specifically addresses the scenario in which a surgeon's failed operation results in the death of an enslaved patient rather than a free person, and in this case, the prescribed consequence shifts dramatically from physical mutilation to a straightforward financial obligation. The surgeon must simply provide the slave's owner with a replacement slave of comparable value, entirely avoiding the severe bodily punishment that would have applied had the deceased patient been a free member of Babylonian society. The practical, real-world consequences of these severe liability standards for the actual conduct and availability of medical care throughout ancient Babylonian society deserve serious consideration, since they illustrate a genuinely important and recurring pattern in the history of professional liability regulation that continues to generate debate among modern policy analysts studying contemporary medical malpractice law, facing the very real prospect of losing both hands, and with them, any possibility of continuing to practice the surgical profession that had likely required years of training and apprenticeship to master. Babylonian surgeons had powerful, entirely rational incentive to avoid taking on the most difficult, uncertain, and high-risk medical cases, precisely the cases where patients faced the most serious underlying conditions and consequently stood to benefit most from whatever surgical intervention medical knowledge of the period could offer. Historians studying the practical operation of Babylonian medicine under this legal framework have generally concluded that the severity of the code's malpractice provisions likely discouraged experienced surgeons from attempting treatment of patients whose prognosis already appeared poor or uncertain, since a patient who died from their underlying condition, regardless of treatment, still exposed the treating surgeon to the same severe liability as a patient who died from genuine surgical error, a genuinely significant unintended consequence that echoes, in striking historical parallel, similar concerns modern policy analysts continue to raise regarding the potential chilling effects of excessively severe malpractice liability standards on physician willingness to treat high-risk patients in contemporary medical practice. The Code's broader treatment of medical practice extended well beyond surgical liability alone into a comprehensive fee schedule specifying exactly how much a physician could legally charge for various categories of successful treatment, again calibrated according to the social class of the patient being treated. A physician who successfully treated a serious wound for a member of the Awilu elite class could charge a substantially higher fee than the same successful treatment performed for a Mushkenu commoner, or, at the lowest tier, for an enslaved patient, whose treatment fee was paid not to the patient, but to that patient's owner. This fee structure, considered alongside the malpractice liability provisions, paints a picture of Babylonian medicine as a genuinely professionalized occupation operating under detailed state regulation covering both compensation and liability, a level of formal legal structure governing medical practice that would not find a comparably comprehensive parallel in many other ancient, or even considerably later, medieval societies, where medical practice often remained governed by informal guild custom or religious institutional oversight, rather than by detailed, state-sanctioned legal code specifying exact fees and exact liability consequences for every major category of medical outcome. For all its genuine historical significance as one of the earliest comprehensive written legal codes in human history, Hammurabi's system of justice was emphatically not built upon any principle resembling modern conceptions of equal treatment under the law. The severity and specific form of punishment the code prescribed for any given offense depended fundamentally on the social class occupied by both the perpetrator and the victim involved in any particular case, producing a system of justice that modern observers would readily recognize as deeply and explicitly discriminatory by contemporary ethical standards. However unremarkable this class-based approach appeared within its own ancient historical context. Babylonian society under Hammurabi's rule was formally organized into three distinct social classes, each carrying different legal rights, obligations, and protections under the code. At the top of this social hierarchy stood the Awilu, a class comprising the free landowning elite, government officials, and other individuals of established high social standing. Below this elite class stood the Mushkenu, generally understood by historians as free commoners of lesser means and social standing, craftsmen, small landholders, and other ordinary working members of Babylonian society who lacked the elite status and property holdings of the Awilu class, but who nonetheless retained personal freedom and certain legal protections unavailable to those below them. At the bottom of this formal social hierarchy stood the Wardu, the enslaved population, whose legal status under the code, as the following paragraphs will detail, differed dramatically from that of either free class above them. The lex talionis principle of proportional physical retaliation, examined earlier in this series, it turns out, applied only within this class structure rather than across it. If a member of the Awilu elite class destroyed the eye of another Awilu, the code's straightforward eye for an eye principle applied directly, and the offender's own eye would be destroyed in exact retaliation. But if that same Awilu instead destroyed the eye of a Mushkenu commoner, the punishment shifted entirely from physical retaliation to a financial penalty. The offending Awilu was required to pay a fine of 1 mina of silver, a substantial sum but one that allowed a member of the elite class to entirely avoid the physical punishment that would have applied had his victim belonged to his own social class. The reverse scenario, in which a Mushkenu commoner struck a member of the Awilu elite class, carried punishment of an entirely different character and severity. Rather than the proportional retaliation or financial penalty that governed conflicts within a single social class, the code prescribed corporal punishment for a commoner who struck an elite, 60 lashes administered publicly with an ox-hide whip, a punishment that, while not capital, represented a genuinely severe physical ordeal, specifically calibrated to reinforce and enforce the existing social hierarchy between the two classes. The Wadu, or enslaved population, occupied a legal category that the code treated in terms strikingly explicit, even by comparison with the already unequal treatment the Awilu and Mushkenu classes received relative to one another. Under the code's provisions, an enslaved person was treated legally as property belonging to their owner, rather than as an independent legal person possessing personal rights of their own. If a free person caused physical injury to an enslaved person belonging to someone else, the resulting legal remedy was calculated not as compensation owed to the injured enslaved individual, but as compensation owed to that enslaved person's owner for the resulting reduction in the enslaved person's economic value or usefulness, functionally identical in its underlying legal logic to the compensation a court might order for damage done to a farm animal or other valuable piece of property belonging to someone else. This explicit, formally codified system of class-based legal inequality offers modern historians a genuinely revealing window into how ancient Babylonian society actually understood and organized the concept of justice, distinguishing it sharply from the modern ideal. However imperfectly realized in practice across even the most contemporary legal systems, that formal legal equality should apply to all citizens regardless of social class, wealth, or status. Hammurabi's code makes no pretense whatsoever of pursuing this kind of formal equality. It instead explicitly and systematically calibrates the severity of both crime and punishment according to the specific social position of everyone involved, treating the existing social hierarchy not as an incidental background condition to be worked around, but as a fundamental organizing principle that the law itself was specifically designed to reinforce and perpetuate across every category of legal dispute the code addressed. It is worth situating this class-based legal structure within the broader economic and social realities of Babylonian society that made such a system seem, to its contemporaries, an entirely natural and unremarkable way of organizing justice, rather than a glaring injustice requiring correction. Slavery in ancient Babylon was not, as it would later become in certain other historical contexts, rigidly hereditary, or based on any fixed racial or ethnic category. Individuals could and did become enslaved through several distinct pathways: captured in warfare, sold into slavery to satisfy family debts as examined in a later episode of this series, or born to already enslaved parents. And it was similarly possible, within certain circumstances the code itself regulated, for an enslaved individual to eventually purchase or otherwise obtain their freedom and re-enter Babylonian society as a free commoner. This relative fluidity between social categories, while certainly not equivalent to anything resembling modern conceptions of social mobility or equal opportunity, meant that the Awilu, Mushkenu, and Wadu, classes the code so carefully distinguished, were understood by contemporary Babylonians less as fixed, immutable categories of inherent human worth and more as functional legal and economic statuses that a given individual might occupy at different points across their lifetime, depending on the fortunes of war, debt, and family circumstance. A distinction that does not make the code's differential treatment of these classes any less troubling by modern ethical standards. But that helps explain why this system of legally codified inequality did not provoke, so far as the surviving historical record indicates, the kind of sustained internal moral or philosophical challenge that comparable systems of legal inequality would eventually face in other historical contexts many centuries later. Marriage and family relationships in ancient Babylonian society functioned, under Hammurabi's legal framework, less as private personal arrangements between individuals and considerably more as formal economic and social contracts binding entire families together, carrying legal consequences of genuine severity when the terms of these arrangements were violated. The code's treatment of marital infidelity illustrates this framework with particular clarity and severity. Law 129 addresses the specific scenario of a married woman discovered engaging in sexual relations with a man other than her husband, prescribing what appears, on its surface, to be an unambiguous and severe capital punishment. Both the wife and her partner in the affair were to be bound together and thrown into the Euphrates River to drown. The code, however, immediately qualifies this severe prescribed punishment with a notable exception that reveals something genuinely significant about where ultimate authority over this specific matter actually resided within the Babylonian legal and social system. If the woman's husband chose to forgive her infidelity, the code specifies that her male partner in the affair would likewise be spared execution, his fate directly bound to whatever decision the wronged husband personally made regarding his wife. This provision demonstrates that, whatever the code's formal prescribed punishment, the ultimate power to determine whether that punishment would actually be carried out rested with the individual husband rather than with any independent judicial authority applying a fixed, non-negotiable legal standard. A genuinely significant qualification that placed substantial personal discretion in the hands of the specific individual most directly affected by the alleged offence. The code additionally addressed the more legally complex scenario of accusations of infidelity that lacked clear, direct evidence or eyewitness testimony sufficient to establish guilt through conventional judicial proceedings. In these ambiguous cases, Babylonian law turned to a practice historians categorize as a trial by ordeal, specifically what has come to be known as the river ordeal. An accused woman, lacking clear exculpatory evidence, would be required to jump into a significant body of flowing water, generally understood to be a substantial river given the physical demands the ordeal was expected to impose. The underlying logic governing this ordeal reflected genuine ancient Mesopotamian religious belief regarding divine intervention in human affairs. If the accused woman drowned during the ordeal, this outcome was interpreted as clear divine confirmation of her guilt. The gods themselves, in this understanding, had rendered judgment by allowing her to die in the water. If, however, she managed to survive the ordeal and swim safely to shore, this survival was interpreted as equally clear divine confirmation of her innocence, since the gods had intervened to preserve her life specifically because she did not deserve to die for a crime she had not actually committed. The code additionally addressed the practical consequences for an accuser whose accusation proved, through this ordeal, to have been false. If a woman survived the river ordeal and was thereby determined innocent, the man who had originally brought the accusation against her faced the prospect of execution himself. A provision specifically intended to discourage frivolous, malicious, or unfounded accusations of infidelity by attaching genuine, severe personal risk to the act of making such an accusation without sufficient supporting evidence to establish the matter through conventional judicial proceedings instead. Modern historians and legal scholars examining these provisions generally note the genuinely troubling epistemological and practical problems inherent in trial by ordeal as a method of establishing factual guilt or innocence, an accused woman's actual swimming ability, physical strength, the specific river conditions on the day of her ordeal, and simple chance all played at least as significant a role in determining the ordeal's outcome as any question of her actual innocence or guilt regarding the underlying accusation. Nonetheless, trial by ordeal of broadly similar character would persist as a recognized, if increasingly controversial, method of judicial proof across numerous subsequent legal traditions throughout the ancient and medieval world, extending well beyond ancient Mesopotamia into medieval European legal practice many centuries later, illustrating the genuinely long historical persistence of this particular approach to resolving legal disputes that lacked clear, conventional evidentiary resolution. Beyond adultery specifically, the code addressed a broad range of additional family and marital matters with the same characteristic attention to detail that runs throughout its other provisions. Marriage itself required a formal contract, and the code specified that a marriage lacking a properly documented contract held no legal standing whatsoever, a provision that, whatever its other implications, underscores yet again the broader Babylonian legal culture's emphasis on written documentation as the foundation of legally enforceable rights and obligations. The code also addressed divorce, permitting a husband to divorce his wife relatively easily under a range of circumstances, while affording a wife considerably more limited grounds on which she herself could initiate a divorce from her husband, generally restricted to circumstances involving the husband's serious neglect or mistreatment that she could substantiate before a court. Inheritance law received similarly detailed treatment, with the code specifying default rules governing how a deceased man's property should be divided among his surviving sons, while also addressing more specific scenarios such as the inheritance rights of children born to a man through a secondary wife or concubine, and the property claims of a widow who had brought her own dowry into the marriage and who, under the code's provisions, retained the right to reclaim that dowry property following her husband's death, rather than seeing it automatically absorbed into her husband's broader estate and distributed among his sons. This attention to protecting a widow's independent property interest represents one of several genuinely notable instances throughout the code in which Babylonian law extended meaningful, if still limited by modern standards, legal protection to women navigating the aftermath of a husband's death within an otherwise thoroughly patriarchal legal and social structure. Beyond its extensive and frequently severe provisions governing violent crime, professional liability, and family law, Hammurabi's code additionally addressed a remarkably comprehensive range of economic and commercial regulations, establishing standards that historians studying ancient economic history have identified as genuinely sophisticated by the standards of the ancient world, and that bear striking, if imperfect, resemblance to categories of economic regulation modern societies continue to maintain nearly 4,000 years later. Among the code's most historically notable economic provisions were specific regulations establishing minimum daily wages for various categories of skilled and unskilled labor throughout the Babylonian economy. Specific provisions established the minimum daily compensation, generally calculated in terms of grain or measured quantities of silver, that construction laborers, ox drivers, and various categories of skilled craftsmen were legally entitled to receive for their labor. This represents one of the earliest documented examples anywhere in recorded history of formal, legally mandated minimum wage regulation, specifically designed to protect ordinary working laborers from potential wage exploitation by wealthier employers who might otherwise possess the economic leverage to depress compensation below levels the state judged fair and sustainable for ordinary Babylonian workers and their families. The code's treatment of debt and lending arrangements reveals a similarly detailed and, in certain respects, genuinely protective regulatory framework governing what could otherwise have become a genuinely exploitative relationship between creditors and debtors throughout Babylonian society. Recognizing that agricultural communities remained perpetually vulnerable to the unpredictable effects of drought, flood, and other natural disasters entirely beyond any individual farmer's control, the code specifically provided that farmers whose crops failed due to drought or flood conditions were entitled to a formal one-year suspension of debt repayment obligations, during which period no additional interest could accrue on their outstanding debts. A genuinely significant protection for a population whose economic survival depended entirely on agricultural output that remained subject to weather conditions no individual farmer could control or predict. The code additionally addressed commercial fraud with characteristic severity, prescribing capital punishment for tavern keepers found guilty of diluting beer with water to defraud their customers, or for merchants discovered using deliberately inaccurate weights and measures to cheat customers during commercial transactions. Provisions reflecting genuine concern for maintaining basic commercial trust and honest dealing throughout the broader Babylonian marketplace, backed by consequences severe enough to provide genuine deterrent effect against the kind of small-scale, difficult-to-detect commercial fraud that might otherwise have proven tempting to unscrupulous merchants operating with relative impunity in the absence of such severe legal consequences. Perhaps the code's most historically significant and, in certain respects, genuinely humane economic provision addressed the specific institution of debt slavery, a common practice throughout ancient Mesopotamian society, in which an individual unable to repay accumulated debts could be compelled to sell himself, his wife, or his children into slavery specifically to satisfy the outstanding obligation. Rather than permitting this arrangement to continue indefinitely, potentially trapping entire families in permanent, generational bondage over debts that might have originated from circumstances entirely beyond their control, the code specifically limited the duration of debt slavery to a maximum period of 3 years, after which the enslaved debtor was legally entitled to automatic release and restoration of their free status, regardless of whether the underlying debt had been fully satisfied through their period of compelled labor. This specific limitation represents a genuinely significant, if still ethically troubling by modern standards, attempt to balance the legitimate interests of creditors seeking repayment of legitimate debts against the broader social and humanitarian concern of preventing permanent, hereditary enslavement arising simply from unfortunate economic circumstance, rather than from any of the more severe criminal offences the code separately addressed elsewhere in its provisions. Historians studying comparable debt slavery institutions across other ancient Near Eastern societies have generally noted that Hammurabi's 3-year limitation represented a meaningfully more protective standard than many contemporary or subsequent ancient legal systems provided for debtors facing similar circumstances, reflecting the same underlying concern for balancing economic order against basic humanitarian protection that runs, in varying degrees of consistency, throughout numerous other provisions scattered across the broader code. The code's economic provisions extended further still into the regulation of commercial partnerships, agricultural tenancy arrangements, and the specific obligations owed between landowners and the tenant farmers who worked their fields under various sharecropping arrangements common throughout Mesopotamian agricultural practice. A landowner who rented out agricultural land to a tenant farmer was entitled, under the code's provisions, to a specified portion of the resulting harvest, with the exact proportion varying according to whether the landowner had also supplied seed, draft animals, and agricultural tools, or whether the tenant farmer had been required to provide these resources from his own means. The code additionally addressed the specific obligations of a shepherd hired to tend another person's livestock, specifying compensation the shepherd could claim for his labor, while also establishing his liability for any animals lost through his own negligence, distinct from losses attributable to disease, wild animal predation, or other circumstances genuinely beyond the shepherd's reasonable control. This granular attention to the specific economic relationships that structured everyday agricultural and commercial life throughout Babylonian society reveals a legal system concerned not merely with dramatic instances of violent crime, but with the ordinary, recurring economic transactions and disputes that most directly affected the daily livelihoods of the substantial majority of the empire's population, who worked the land or tended livestock rather than practicing the more specialized trades of surgery or construction that this series' earlier episodes have examined in detail. Among the most historically significant and enduringly influential principles embedded within Hammurabi's legal code is one that continues to function as a foundational element of virtually every modern legal system operating anywhere in the contemporary world. The presumption of innocence, the principle that an accused individual should be considered innocent of a charged offense, unless and until sufficient evidence is presented to a court to establish their guilt through proper judicial process. The very first law recorded on the stele addresses this principle directly and with characteristic severity regarding false or unsubstantiated accusations. If a person accused another individual of murder but failed to produce sufficient evidence and credible witness testimony to substantiate that accusation before a court, the code specified that the original accuser himself would face execution in place of the person he had falsely or unsubstantiatedly accused, an extraordinarily severe deterrent against the practice of leveling serious criminal accusations without sufficient supporting evidence to actually establish guilt through proper legal proceedings. This provision reflects a legal philosophy that, while expressed through punishments modern legal systems would regard as extraordinarily and unacceptably severe, nonetheless established a genuinely important underlying principle, that the burden of proof in establishing criminal guilt rested squarely on the accuser bringing the charge, rather than requiring an accused individual to somehow prove his own innocence against an unsubstantiated accusation. This allocation of the burden of proof, however harshly enforced through the specific mechanism of potential execution for false accusers, represents a genuinely foundational contribution to the broader development of due process protections that subsequent legal traditions across numerous different civilizations would continue refining and developing across the following several thousand years of legal history. The code's treatment of theft and property crime reveals a similarly severe, if internally consistent, approach to establishing and enforcing legal accountability. Theft from temples or from the royal palace carried an unconditional death sentence, without any of the mitigating circumstances or reduced penalties that governed theft from ordinary private individuals elsewhere in the code, reflecting the particular religious and political significance ancient Babylonian society attached to property associated with sacred institutions and royal authority. More strikingly still, the code extended severe liability even to individuals who had unknowingly purchased stolen property without any actual knowledge or intent to participate in the underlying theft. If a person purchased goods from a seller, and it was subsequently discovered that those goods had been stolen, the purchaser bore the burden of proving, through witnesses or other satisfactory evidence, that he had purchased the property in good faith, and had no reasonable means of knowing it had been stolen. Failing to establish this good faith defense to the court's satisfaction, the purchaser himself faced execution as though he had been the original thief, a genuinely severe standard of liability that placed substantial practical burden on ordinary commercial buyers to verify the legitimate provenance of goods they purchased, given the severe personal consequences of unknowingly acquiring stolen property without adequate proof of their own innocent intentions. The code's treatment of burglary specifically prescribed a punishment of genuinely striking symbolic character. A convicted burglar was to be executed, and his body either buried or hung directly at the location of the wall breach through which he had originally broken into the victim's property, a punishment specifically designed to serve as a permanent, visible warning to the surrounding community regarding the fate that awaited anyone who might contemplate similar crimes against their neighbor's property in the future. Perhaps the code's most narratively striking property crime provision addresses a scenario combining genuine communal crisis with individual moral failure. If a house caught fire and a neighbor who entered the burning structure to help extinguish the flames or rescue the occupants instead took advantage of the chaotic circumstances to steal property belonging to the homeowner, the code specified that this opportunistic thief should be thrown directly into the same fire he had originally entered under the pretense of offering assistance, a punishment whose poetic, almost narratively satisfying symmetry illustrates, with particular vividness, the broader logic of proportional, symbolically resonant justice that runs throughout the entire code, extending well beyond the more famous eye for an eye provisions. This series' third episode examined in detail into virtually every category of offense the code's 282 individual laws collectively addressed. The code's treatment of false testimony and perjury more broadly deserves attention alongside these specific provisions regarding false accusation of murder, since it reveals a consistent underlying concern throughout the entire legal document with protecting the basic integrity of judicial proceedings themselves. A witness who gave false testimony in a capital case, one carrying the possibility of a death sentence for the accused, faced execution himself if his false testimony was subsequently discovered and proven, mirroring the same severe standard the code applied to false accusers more generally. In cases involving grain or money rather than capital charges, a witness proven to have given false testimony faced whatever penalty the false testimony would have caused the wrongly accused party to suffer, applied instead to the false witness himself, again reflecting the same underlying principle of proportional, mirrored consequence that the code applied so consistently across its many different categories of offense. This sustained attention to punishing false testimony, with a severity calibrated directly to the harm that testimony could have caused an innocent party, reflects a genuinely sophisticated understanding, for its historical period, of just how central reliable, honest testimony was to the basic functioning of any judicial system claiming to dispense genuine justice rather than simply processing whatever accusations happened to be brought before it, regardless of their underlying truth or falsity. Hammurabi's Babylonian Empire, for all its genuine military and administrative achievement during his own lifetime, did not survive as a unified political entity for very long following his death. Within roughly a century, the empire he had assembled through decades of calculated conquest and diplomacy had fragmented considerably, though the specific legal code he had established continued to exert genuine, documented influence on subsequent Mesopotamian legal practice and administrative tradition for many centuries afterward, copied and referenced by subsequent scribes and administrators long after Hammurabi's own dynasty had ceased to rule Babylon directly. The stele itself, however, experienced a genuinely dramatic historical journey of its own across the following centuries. Sometime around the 12th century BC, roughly 6 centuries after Hammurabi's original reign, an Elamite king launched a successful military campaign against Babylon and, among the substantial plunder his forces carried away from the conquered city, took the great stone stele itself as a prized trophy of conquest, transporting this massive, multi-ton monument across a considerable distance to the Elamite capital of Susa, located in territory corresponding to modern southwestern Iran. Once installed in Susa, the stele remained on display for some additional period, before eventually being lost to history entirely, buried beneath accumulated soil and debris across the following centuries and millennia, its existence and specific location gradually fading from any surviving historical memory or written record. For roughly 3,000 years, this massive stone monument, once one of the most publicly prominent and symbolically significant objects in the entire ancient Mesopotamian world, lay entirely forgotten beneath the accumulated earth of a site that had itself been abandoned and forgotten by the wider world for many centuries. This remarkable historical disappearance finally ended in 1901 and 1902, when a French archaeological expedition, led by Jacques de Morgan, excavating the ancient site of Susa in what is now Iran, discovered the stele in 3 broken but largely intact fragments, buried within the site's accumulated archaeological layers. The discovery represented one of the most significant archaeological finds of the early 20th century, providing scholars with an essentially complete, remarkably well-preserved copy of one of the oldest and most comprehensive legal codes ever recovered from the ancient world, inscribed in its original cuneiform text, and largely undamaged by its 3 millennia spent buried beneath the earth. Following its discovery and subsequent careful restoration, the stele was transported to Paris, where it has remained on prominent public display at the Louvre Museum ever since, allowing modern visitors to stand before the same towering black stone monument that ancient Babylonian citizens once encountered in the central public spaces of their own city nearly 4,000 years earlier, a genuinely remarkable continuity of physical object, bridging one of the longest spans of time, separating any ancient artifact from its modern public display and appreciation. The code's broader historical influence and legacy extends well beyond its own specific historical period and geographic context, into the development of subsequent legal traditions across the ancient Near East, and, many scholars argue, into the foundational legal traditions of Western civilization more broadly. Scholars studying the ancient Israelite legal tradition preserved in the Hebrew Bible have long noted the striking similarities between certain provisions of Mosaic law, particularly the eye for an eye formulation appearing explicitly in the Book of Exodus, and the corresponding lex talionis provisions found throughout Hammurabi's earlier Babylonian code, a resemblance that most historians attribute not to any direct, deliberate borrowing between the 2 specific legal traditions, but to a shared broader cultural and legal heritage common throughout the ancient Near Eastern world, within which similar approaches to proportional justice appear to have developed independently across multiple related Semitic-speaking civilizations, occupying the same general region across overlapping historical periods. It is worth noting explicitly, in concluding this series, that Hammurabi was not, strictly speaking, history's first lawgiver in the most literal sense. Earlier, more fragmentary Sumerian legal codes, including the Code of Ur-Nammu, predate Hammurabi's own code by several centuries, addressing many similar legal subjects in less comprehensive and systematic form. What distinguishes Hammurabi's specific historical achievement, and what accounts for the enduring fame his code has retained across nearly 4,000 years of subsequent human history, was not raw priority as the very first written law, but rather the unprecedented comprehensiveness, systematic organization, and calculated public visibility with which he assembled, inscribed, and displayed his legal system, transforming what earlier rulers had treated as a relatively narrow, specialized administrative exercise into a sweeping, monumentally displayed public statement about the fundamental nature of justice itself. The code's rediscovery in 1901 also arrived at a historically significant moment for the broader development of legal history and comparative jurisprudence as academic disciplines, coinciding with a period of intense scholarly interest in tracing the origins and development of legal institutions across different ancient civilizations. Legal scholars and historians who studied the newly discovered text in the years immediately following its excavation found themselves confronting a document considerably more sophisticated, more comprehensive, and more internally organized than many had previously assumed possible for a legal system nearly 4,000 years old, prompting a broader reassessment of just how early in human history genuinely systematic, written legal codification had actually emerged. This scholarly reassessment continues, in various forms, to the present day, as archaeologists and historians studying ancient Mesopotamia continue to recover additional textual fragments and comparative legal documents from other ancient Near Eastern civilizations that help situate Hammurabi's code within its broader regional legal tradition, refining and deepening modern understanding of exactly how this remarkable ancient legal achievement fit within the wider constellation of early written law that emerged across the ancient Near East during the 2nd and 1st millennia BC. However harsh, however explicitly class-biased, and however ethically troubling many of its specific provisions appear when measured against modern standards of justice and human rights, the underlying principle Hammurabi's code first established at this unprecedented scale, that a stable, prosperous society requires governance through fixed, publicly known and consistently applied law rather than through the arbitrary exercise of unchecked power, remains, nearly 4,000 years later, one of the most foundational and enduringly influential ideas in the entire history of human civilization.